This is a really common question. Often clients come later in life, they've made a will when they were younger and their circumstances have changed. It might be that someone has got a diagnosis for dementia and they're going into care and the will doesn't do what they wanted it to do. They need to make some changes. Mental capacity is not black and white. It's not a case of one day you can make all your decisions and the next day you can't make any. It really depends on what mental capacity you need to make the decision at hand. So in relation to making a will, we call this testamentary capacity. And what we're looking for is whether someone has the testamentary capacity in order to make a will. Testamentary capacity requires someone to A, understand what a will is and the effect that it will have, B, to understand the extent of their estate and what they have to gift in their will, C, they will need to know who their family are and who might be able to make a claim against their estate, and D, they need to have no disorder of the mind that might get in the way of them making a will. And just by way of an example, if I was a schizophrenic and I was paranoid about my daughter, believing that she was out to get me or wanted to steal from me, I might not include her in my will. But it would be the schizophrenia that would be getting in the way of me being able to see clearly. It's also important to bear in mind that capacity to make a will is not a memory test. Someone may have a poor memory, but it will not preclude them from being able to make a will. And also, when deciding whether someone has capacity, it's on the balance of probabilities. That means, is someone more likely to have capacity or less likely to have capacity to make a will? So the person making the test is likely to be a GP or an independent social worker, and they do not have to be satisfied beyond reasonable doubt. Medical evidence is often very important in deciding whether someone has capacity or not to make a will. And for a professional practitioner, our golden rule is that if we are acting for someone that is very old or seriously unwell, we obtain a medical assessment because it can help if there is a future claim against someone's estate. If it is determined that someone does not have the capacity to make a will, it is still possible to make a will by making an application to the Court of Protection. The Court of Protection is a special court that makes decisions for people that cannot make them for themselves. So if a will does need to be made by the Court of Protection, this is referred to as a statutory will. By making an application to the Court of Protection, and that application will include a statement as to the testamentary capacity. It will need to include the grounds for either changing an existing will or making a first will. It will also need to include details of all the beneficiaries that may be affected by the change. There will also need to be included a financial breakdown of the testator's estate, including any arrangements for their care. It will also need to include a family tree. And lastly, it will need to include a draft of the statutory will. It's more than likely to be either an attorney that's acting for someone who's lost capacity or a deputy that's been appointed by the court. And also, any beneficiary that might be affected could also make an application. First of all, they would appoint an official solicitor, which is someone that steps in to have a look at the process and make sure that everybody involved is being treated fairly. They would also invite any of beneficiaries that might be prejudiced by the changes to be a party to the application. However, the court will have the final say as to what will go into the statutory will. The court will, however, consider the following. Firstly, the testator's previous and present wishes and feelings. They will also look at the best interests of the testator. And they will also want to know what the testator's views are. Even if they don't have capacity to make a will, they will still want them to have some involvement in the process. And they will also look at the views of any third parties that would be affected by the change. Once the will has been approved by the court, they will issue an order that will allow the applicant to sign the will on behalf of the testator. The will is then sealed by the court, and it's that seal that makes it a legally binding document.